Hello everyone, introduce us from the group of where we'll practice the simulation of the International Court of Justice about the Ashmore and Cartier Island. My name is Anisa Khairunisa as a President's Judge.
My name is Boma Wikan as Honorable Judge.
My name is Hartantha as Honorable Judge.
My name is Bagas Priambodo as the Agent of Republic of Indonesia.
My name is Dion Azriel as Indonesian representative.
My name is Setyo Ardiansyah as a representative of Indonesia.
My name is Fahri Pratama as Australian representative.
My name Muhammad Rifqi Maulana as Australia delegation.
My name is Najlaa Putri Virdiansyah as representative of Australia.
The sitting is open. The meet for today is to hear the first round of the case concerning the ownership of Ashmore Reef and Cartier Island dispute. The parties are applicant the Republic of Indonesia versus respondent Australia. I shall now give the floor to the agents of the Republic of Indonesia. Her Excellency Mr. Bagas, you have the floor, sir.
Thank you, Madam President, and the members of the court. It is an honor to appear as agent of Republic Indonesia in this presidency. In this court, Mr. President, we need to realize that the distance from Roti Island to Ashmore Island is only 78 nautical miles, while the distance from Australia's west coast is 190 miles. Even the closest land in Australia itself, Broome, is still very far from Ashmore Reef, up to 3 times the distance between Roti Island and Ashmore Reef. The distance from Rote to Ashmore Reef is approximately 6 hours away by using a traditional boat. Thus, according to that distance, Rote Island is the nearest place to Ashmore Island, more than Australia's west coast. To conclude, Madam President and the court, the Ashmore Reef and Cartier Island location is closer to our territory than to Australia's land itself. We thus believe the island shall belong to Indonesia as our citizens in the context the Rotan people live their lives from its surroundings. We beg the court to take an action and resolve the dispute. Madam President and the court members, I thank you for your attention, and I would like to call Mr. Dion Azriel to continue our statement on behalf of Indonesia.
I thank Her Excellency Mr. Bagas as the agents of Republics of Indonesia for your statement. I now invite Mr. Dion Azriel to take the floor.
Thank you very much, Madam President and the member of the court. It is an honor to me to appear before the court. The hearing of presentation today is regarding the historical records which are according to the Dutch archival records that traditional Indonesian fishermen discover Ashmore Island and utilize it since Verinage us Indisci in Timor in 1602. And then at the end of 1750s, the collection of sea cucumbers and other marine life from Ashmore Island had been regulated by the VOC. And at the time, many boats from Makassar arrived in the island of Timor with complete official permits from Netherlands that allow Makassar fishermen to collect sea cucumber and other marine life without obstacles in Ashmore Island. This fact proves that Ashmore Island is a Dutch colony, which should have been inherited by Indonesian, not Australia. Based on the local, in this context, the Rotanese people itself believe that the Ashmore Reef was discovered in 1729 by Fou Mbura, the fifth ruler of Nusak Tilong, before the arrival of Captain Ashmore from Great Britain. the ownership of those islands to prove by the existence of 161 graves of the fishermen from Rhodes, based on the register letter of the governor of the Netherlands in 1751 and the Dutch colonial reports in 1728. Madam President and all the court members, we believe the one who should have the right over the island of Indonesia is Indonesia. I thank Madam President, the panels, and all the spectators for the intention. And I would like to call Mr. Setyo Ardiansyah to continue our statement on behalf of Indonesia. Thank you.
I thank Mr. Dion Azriel on behalf of Indonesian for their statement. I now invite Mr. Setyo Ardiansyah to take the floor. You have the floor, sir.
Thank you very much, Madam President and a member of the court. It is an honor to speak before you again. Now I'm on behalf of Indonesia. I will address between Indonesia and Australia according to Her Excellency Mr. Bagas' statement before. We also need to remember the traditional fishermen conducting their fishing activity as part of the long-term fishing tradition are recognized and allowed to catch fish. In the 1974 Memorandum of Understanding MOBOX, there was an agreement between Australia and Indonesia which stated that the traditional fishing by Indonesian fishermen will be the state allowed to catch fish various types of mollusks on the five islands Australia, including the Ashmore Reef and the Cartier Island, which are one of the closest islands from the East Nusa Tenggara. In addition, traditional fishing rights in the region other countries and internationally are possible considering the 1982 UNCLOS in Article 51, which counted respect for the existence of XPT, traditional fishing right. This is also regulated in Article 87 of the 1982 Law of the Seas Convention, which states the high seas are open to all countries, both coastal countries, coastal states, and countries not landlocked states. All countries have seek freedom on the high seas, freedom of the high seas, one of which is freedom of fishing. Thus, in the Ashmore and Cartier Island. With this statement, we believe Indonesia is the one who maintain and utilize the world of natural resources for local life and also prove the activity of Indonesian. We would like to refer to the case of Sipadan and Ligitan back in the 2002, which state it belonged to Malaysia on basic of the activity by the local that proved to be the sovereignty of the land. With this, Madam President and the court member, we beg the sovereignty over the Ashmore Reef and Cartier Island to belong to Indonesia. I thank Madam President and the panel of the honorable judges for the attention. I now shall excuse myself as representative of Indonesia. Thank you.
I thank Mr. Setyo Ardiansyah for their statement. Your statement concludes the first round of the first hearing. The court will meet again tomorrow, 8 December at 10 a.m. to hear the two-end round of the court. I recall that each party have a maximum of 90 minutes for present the statement. The sitting is now adjourned. The sitting is open. The meet for today is to hear the two-end round of the case concerning the ownership of Ashmore, Reef, and Cartier Island. The parties are applicants the Republic of Indonesia versus respondent Australia. I shall now give the floor the agents of Australia, Her Excellency Mr. Fahri Pratama.
Thank you very much, Madam President and the members of the court. It is an honor to speak before you again. With this, may I explain that by astronomical coordinates of Ashmore Reef is 12 degrees 3898 south latitude and 123.4.98 east longitude. In the map of the boundary agreement between Indonesia and Australia, it is clear that Ashmore Reef and Carrier Island are in the Australian EEZ region. This indirectly shows that at least in 1997, when the EEZ agreement was made, Indonesia, through its diplomat, had recognized Australia's sovereignty over Ashmore Island and its surrounding. With this, Australia believes Indonesia doesn't have right reason to claim the ownership of Ashmore Reef and Cartier Island based on its location. As Australia has been legally acknowledged as the rightful owner of Ashmore Reef and Cartier Island, Thank you, Madam President, and the court members for the attention. And I would like to call Mr. Rifqi Arfan to continue our statement on behalf of Australia. Thank you.
I thank Her Excellency Mr. Fahri Pratama as the agents of Australia for their statement. I now invite Mr. Rifqi Arfan to take the floor. You have the floor, sir.
Thank you very much, Madam President and the member of the court. It's an honor for me to speak before you again. In this statement, I would like to explain the history over the ownership of Ashmore. In between 1878 and 1909, there was a dispute between the United States and Great Britain over the ownership of Ashmore, result in confirmation of British sovereignty and annexation of Cartier Island. In 1993, British order in council stated that Ashmore and Cartier Island would be placed under the authority of the Commonwealth of Australia when Australia passed legislation to accept them. The Commonwealth, resulting Ashmore and Cartier Island Acceptance Act 1933, came into operation on 10 May 1934 when the island formally became a territory. The act authorized the governor of Western Australia to make ordinance for the territory. In July 1938, the territory was annexed to the Northern Territory, then also administered by the Commonwealth, whose law, ordinance, and regulation applied to the Northern Territory. When self-government was granted to the Northern Territory on 1 July 1978, administration of Ashmore and Cartier Island was retained by the Commonwealth. In 1983, the territory was declared a nature reserve under the National Park and Wildlife Conservation Act 1975, now replaced by the Environment Protection and Biodiversity Conservation Act 1999. With this statement has proven the sovereignty over the Ashmore and Cartier Island belongs to Australia. And we also declared the refusal to transfer the ownership over the territory to Indonesia. I thank Madam President and the court member for the attention, and I would like to call Mrs. Najlaa Virdiansyah to continue our statement on behalf of Australia.
I thank Mr. Rifqi Arfan for their statement. I now invite Mrs. Najlaa Virdiansyah to take the floor. You have the floor, ma'am.
Thank you very much, Madam President and the members of the court. It is an honor to speak before you again. Now I'm on behalf of Australia. I will explain that based on MOU 1947, there is agreement between Indonesia and Australia about Ashmore Reef and Cartier Island. The agreement about Australia ownership of Ashmore Reef and Cartier Island, which is approved by Indonesia. Australia also doesn't violate the provisions agreed in the MOU 1947. As Ashmore has been regularly visited and fished by Indonesian fishermen since the early 18th century, we the Australia understand the importance of Ashmore and Cartier Island to the Rottenness people, with thus we agreed traditional fishers can access resources in Australia's territorial sea and the region. This allows this allows traditional Indonesian fishermen to access parts of Ashmore for shelter, freshwater, and to visit grave sites. As Indonesian can prove we met any violation, nor the Australian government sees any faults in the MOU, we shall declare that we have the full sovereignty over the Ashmore and Carter Island and refuse to give up on our ownership. Thank you, Madam President and the court members. I shall now excuse myself as a representative of Australia.
I thank Mrs. Najlaa Virdiansyah for their statement. Your statement concludes the second round of the case. The court will now proceed to a 5 hour break for the panel of judges to discuss. The sitting will resume with the agenda of delivering the decision for the indication of professional measures and the final verdict in the case concerning the dispute over ownership as the Ashmore and Carter Island, Indonesian versus Australia. The sitting is adjourned. The sitting is open. The meet for today is to deliver the decision of the case concerning the possessions of Ashmore and Cartier Island. The parties are applicant the Republic of Indonesia versus respondent Australia. After hearing of all the pleadings delivered by the applicants and the respondents, the panel of judges have discussed in regards to the dispute acquo. We would like to read the provisional measure along with the considerations. Separate into the three main parts, I would like to call Mr. Boma Wikan, one of the judges from the panel, to read the first considerations.
Thank you, Madam President. I will read the first consideration regarding the geographical condition of Ashmore and Cartier Islands. First, on 1st August 1994, Australia declared an exclusive economic zone extending from 12 nautical miles to 200 nautical miles from its coastline. Within its EEZ, Australia has sovereign right to explore and exploit, conserve and manage the natural resources, both living, such as fisheries and genetic material, and non-living, such as oil, gas, and minerals. It also has jurisdiction over offshore installations, marine scientific research, and the protection and prevention of the marine environment. Consistent with international law, Australia has also claimed the sovereign right to explore and exploit the natural resources of the continental shelf, including sedentary species, where the shelf extends beyond 200 nautical miles. Secondly, according to the astronomical coordinates of Ashmore Reefs, 12 degrees 13.98 south latitude, 123 degrees 4.98 is longitude in the map of the boundary agreement between Indonesia and Australia. It is clear that Saint Island is the Australia easy region. The indirectly shows that at least 18 when the easy agreement was made, Indonesia, through its diplomats, has recognized in Australia sovereignty over Ashmore Reef and Carter Island. Third, in conclusion, through the geographical condition of Ashmore and Carter Islands, Australia has sovereignty over Ashmore and Carter Island. That is the end of the first consideration, Madam President, and all the court members. I would like to call Mr. Tegar, one of the judges from the panel, to read the second consideration. Thank you.
Thank you, Mr. Boma. I now invite Mr. Tegar to take the floor. You have the floor, sir.
Thank you, Madam President. I will now continue to read the second consideration regarding the historical data mentioned by both parties. First, in between 1978 and 1909, there was a dispute between the United States and the Great Britain ownership of Ashmore Reef and the Great Britain took the possession of Ashmore Island in 1978 and Carter Island in 1909. Britain gave the territory to Australia in 1933. Ashmore Reef and Carter Island were handled by under Australian government on 23 July 1931. Second, in 1993, British ordered the Council State that Ashmore and Carter Island would be placed under the authority of the Commonwealth of Australia when Australia passed legislation to accept them. The Act of authorized the Governor of Western Australia to make ordinances for the territory. The third, I will now continue to read consideration regarding legal evidence from Indonesia and Australia, Memorandum of Understanding MOU between Government of Indonesia with Government of Australia 1974 about traditional fishing rights and Perth Treaty 1997 that is the treaty between the Government of Australia and Government of the Republic of Indonesia establishing an exclusive economic zone boundary and certain seabed boundaries. The fourth, in conclusion, should historical data of Ashmore and Carter Island, Australia has has sovereignty over Ashmore and Cartier Islands. That's the end of the last consideration.
Thank you, Mr. Tegar. With that, the court has concluded and decided that the ownership of the Ashmore and Carter Islands still belongs of Australia. The court considers the Australian territory and the Ashmore and Carter Island based on the proclamation reserved on 60 August 1983, referring to the Conservation Act 1975. The court also approved the 1974 Memorandum of Understanding or MOU agreement as a permanent legal force stating the ownership of the island of Australia. On the other hand, Indonesian people, especially traditional fishermen, still have the authority to research for their livings from the island with the recruitments according to the 1974 MOU agreement referring to the 1982 unclosed the Cyprian and legitimate jurisprudence with an additional explanation of the definition in one points of the agreement relate to the definition of traditional fishermen, specified into traditional fishermen are fishermen who use traditional wind power, boats and fishing around the coast. This is the end, the verdict. The order is available from today in the transcript. I will be available shortly on the court website as well as the printed text, as the court has no further business since today forward. I declare the sitting closed. Okay, earlier was the transcript of the our group. Thank you for all your attention.